Guess what? When you're before the bench, do not whisper. I'm amazed that people will whisper when they're before the bench, and this includes attorneys, but then when you're conferring, everybody is speaking so loudly. So whisper. Thank you. It makes it easier for the court reporter, and it makes it for a great Friday Eve. We're trying to bring joy, right? All right, court is calling 2023 CR 0329, State of Texas versus Zachary Sanchez. Could I have parties announced for the record for the state?
Allie Jackson.
Defense.
Michael De Leon for Mr. Sanchez.
And are you Mr. Sanchez?
Yes, ma'am.
And Your Honor, just a reminder that our victim's in the breakout room.
All right. All right, you entered a plea on December 5th, 2023 to the offense of attempted indecency with a child by contact as a third-degree felony. According to the plea bargain agreement, the state is recommending deferred adjudication. Let's go off the record for a moment. I'm not the person who took this plea. You understand? You need to speak up so the court report can hear.
Sorry, yes, ma'am.
All right. So according to the plea bargain agreement, the state is asking that your community supervision be for a term of 5 years. Did anyone want to speak to the length of community supervision, state?
Not to the state, we just feel it's appropriate, Your Honor.
Defense?
Judge, I would just ask for it to be 4 years deferred, and I know a fine wasn't listed in there. I would just, I'm stepping ahead a step, but he works as a cook at Pluckers. So he doesn't make all that much money. on asking maybe if the fine can be probated or be relatively low.
Okay. And what is the court cost in this case, please? All right, Mr. Sanchez, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Zachary Sanchez.
All right, so I've just been told by the clerk the court costs in this case. Will you be able to pay that over a period of time in installments?
Yes, ma'am.
All right, if you can't pay it, just let the court know. You understand?
Yes, ma'am.
All right, and then I have the MIC evaluation. Have everybody seen the mental health evaluation on this case?
I have, Your Honor.
Yes, Your
All
Honor.
right. Any input from either side?
No, Your Honor.
All right. So, Mr. Sanchez, it is saying here that you do need to be placed on a mental health caseload. Probation, based upon the nature of the offense, will mental health still accept him on their caseload?
Employees on the SOMA unit that will assist him with these.
All right. So what I'll do then is I'll say the mental health sex offender unit. There's going to be 4 years deferred adjudication. Chapter 62 compliance. No contact with the complainant in the case. There should be regular reporting by Zoom or in person. There's to be regular UAs, proof of employment within 30 days. There's to be no employment as a health care provider or with minors. There's a request for community service hours, but because of the nature of the offense, there's no community service hours available for you because no one has insurance to do that. You understand? There's to be no unsupervised contact with minors. Probation, is there anything else?
There are, the sex offender unit will take care of the field test, as a field visit.
Yes.
There's nothing else.
All right. Is there anything else you need from the court to be successful? If there's something else you need, now's the time to let me know.
No, it's fine. It's fine. I did make what you did, so, okay.
Nothing, Your Honor.
All right.
Thank the court.
I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Thank you. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. You understand? All right, you all have victim impact?
Yeah, it's on the Zoom.
All right, and is it the Garcia?
Yes.
Okay. And I'll stop video. All right, Ms. Garcia? No. The video is just not shown. All right, Ms. Garcia, if you can unmute, please. All right, Ms. Garcia, Mr. Sanchez is here.
Okay,
And you may proceed with your victim impact.
okay, it's going to be my daughter, Sadie.
All right.
Go ahead. I'm holding.
Zach, I don't know what to say. I could tell you that you ruined my life and how messed up I am. Or I could tell you I forgive you for what you did. I don't know how to feel. I'm angry. I'm angry because I didn't deserve what you did. You were supposed to be there to protect me. You were my family. Family doesn't do that. I needed you most when I was there. I thought I was safe, but I was wrong. Since that day, I've never been the same. I don't go out or wear shorts like I used to. I can't sleep and still have nightmares because of what you did. I can't stand when people touch me anymore, and I can't even let my 9-year-old brother touch me. You turned me into a person I never wanted to be. You turned me into someone who doesn't go to places, into someone who can't be alone in a crowd, into someone who can't stop shaking and who takes pills to be happy. I wish you could explain to me why you did what you did. You took my family away from me. My aunt doesn't want to look at me anymore, and my cousins don't believe or trust and can talk to me anymore. I kept it a secret for so long because I knew what my family would do. I understand that you are family, and I love you. I would never make something up like this. Why would I make something up like this? I knew as soon as I opened my mouth that my family would be gone and I would never be the same. You took everything from me, and yet I still forgive you. I forgive you for me to move on in life. I love you.
All right, thank you so much for coming in.
Thank you.
Thank you, Judge. May we be excused?
Yes, if he'll just remain and speak with the probation officer. All right, thank you. All right, who's here on Christopher Lemire? Lemire? All right, where are we on this case?
We've got an agreement. He's gonna go to ISF.
All right, just 1 moment. Could I have the file stamp, please?
Judge.
Oh, no problem. Thank you. It's not a problem. Mr. Lemire? Is it Lemire or Lemire?
Lemire.
Lemire, we're gonna go on the record. Court is calling 2018 CR 0858, State of Texas versus Christopher Scott Lemire, Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Gary Chirac for the defendant.
And are you Mr. Lemire?
Yes.
I'm going to show you what's entitled Motion to Enter Adjudication of Guilty and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Why you're here in jail for violating your probation.
Okay, yes. Your
Well,
Honor.
no, here's the thing. This document states that you're on probation. Are you aware of that?
Yes, Your Honor.
All right. Do you know why you're here today?
Yes.
All right. So this document that I'm showing you, did you review that with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
All right. Here's the thing, Mr. Lemire. If it's something that you don't understand, just let me know.
Okay,
So this document that I've shown you, did you review that with your attorney? All right. So if you all to step back and review it. 2021 CR 2955, State of Texas versus Victor Alvarez Jr. Can I have parties announced for the record for the state?
Zach Dunn for the state, Your Honor.
Defense?
John Robertson for Mr. Alvarez.
And are you Victor Alvarez?
ma'am.
I'm going to show you what's entitled Motion to Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am. Yes, ma'am.
Are you the same Victor Alvarez Jr. who was placed on community supervision in 2021 CR 2955 for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on July 15, 2021 for a term of 4 years? Is that you?
Yes, ma'am.
All right, state.
Your Honor. Violated condition number 2, on or about the 12th day of December 2023 in Bexar County, Texas, the defendant, Victor Alvarez Jr., did then and there admit illegally using a controlled substance, namely heroin, in violation of condition number 2.
How do you plead to that? True or not true?
True.
State?
Your Honor, the state waives and abandons the other.
Any
conditions.
objections?
No, Your Honor.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, sentence you up to 4 years in the prison and up to $1,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. Is there a proposed agreement?
There is a proposed agreement, Your Honor, yes.
What are you all requesting?
Your Honor, the Victor was in drug court and had some challenges in drug court and was ultimately discharged in December of 23.
Mhm.
The probation department is recommending safety. He had previously been evaluated for SATF and DDRF, but was declined due to his physical condition. He has 2 prosthetic legs. From talking to Victor over the last couple of weeks, I know Victor, he admits he has a drug problem and he wants to continue to work on that. Victor would like to be considered for being put back into the drug court program and continuing to work with them. And I know he'd like to address the court about that.
All right, you'd like to address the court?
Yes, ma'am.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for a record.
Victor Alvarez Jr.
All right, what would you like to say?
I want to say that I messed up. I did my anger getting away, and I've been working a lot, real hard with drug court, trying to focus on my recovery. And before I went to jail, I talked to my counselor at Alpha, and I told her about getting into anger management classes and continuing with treatment there too. And I really want the opportunity to finish drug court, and I finally got the chance to get new prosthetics, and I'm in the process of getting new prosthetics before I came in here. If you give me a chance, I promise you that I will complete drug court, and if I mess up, you can sentence me to whatever amount is right.
All right. Probation,
That's true.
what is your recommendation?
Probation is to extend probation for a year and a half, and it's complete the safety followed by after.
All right, this is what the court will do. The court will deny the motion. alter amend conditions to extend for 2 years. A referral to felony drug court. If felony drug court does not accept him back, then he's going to safety. Is there anything else?
Sorry.
Is there anything else you need from the court to be successful?
You know, do I have to go, can you put me in anger management classes or do they do that?
Oh, yeah, I'll add anger management classes. Thank you.
Thank you.
And also anger management classes. Thanks for letting us know that that's an issue, okay?
Yes, ma'am.
All right. If you need anything and you feel like it's not being addressed by your probation officer, you can always come back to court. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. Felony drug court is a good program, but they can't help you if you're not trying. And what do I mean by that? What I mean by that is throwing up your hands and say, well, I'm just going to use. Because I know in felony drug court, there's a lot of people that you can call. And I know over there, probation officers give you their cell number. You have the cell number to your counselor. So instead of breaking down and using the heroin and meth, you should have just picked up the phone. And you can pick up the phone with them and you can call them and say, hey, this is what's going on. And I'm about to use some heroin and meth. And you know what they do over there? Somebody will either say, come in, let us talk to you, or either they'll go to you or get a ride to you to bring you in to talk to your counselor. But if you don't do that, nobody can help you. You understand?
Yeah.
All right, good luck to you. Don't be the person that they're trying to identify on the side of the road or in a field somewhere and it's you. All right?
Yes, ma'am.
Okay, good luck to you.
Thank you.
Thank you, Judge.
You're welcome.
Judge, I'll document.
Yes,
Renee Gardia, client that was in court last week, and she was having like a mental.
Yes.
episode. She was ED.
Mhm.
She got out of the hospital, I believe, today's Thursday, I believe, yesterday or Tuesday.
Okay.
Contacted me. She's meeting with Center for Healthcare Services today,
Okay.
because they're still evaluating her for mental health court.
Mhm.
But I need to get her in here so we can address her failure to appear.
all right. If you want to bring her in this afternoon or bring her in tomorrow morning, you
Get her
can.
tomorrow morning.
Yes.
Okay, I'll try to get her here tomorrow.
All right, thank you.
Thank you.
Tyler Ashbaugh. All right, why were you late for court?
Oh, the traffic.
You have to plan for traffic.
Yes, ma'am.
Am I late for court? No.
Also, I was trying
And-
to have
so-
I was walking my elderly father. He doesn't walk that fast as well.
You need to plan for that because let me explain something to you. Am I late for court? No. And all the defense attorneys will tell me, oh, judge, why are you rushing? You can be late for court. But I don't ask people to do things that I myself are not prepared to do. Your attorney doesn't have to be on time because guess what? If he's not on time, normally nobody's going to hold him in contempt or put him in jail. But if you're late, guess what?
Yes, Your Honor.
All right.
Yes, ma'am.
Okay, so what's happening with Mr. Ashbaugh's case? We were here last time for discovery. Where are we on discovery?
Your Honor, I believe we have taken care of all the discovery issues in this case. I've been conferring with opposing counsel since the last court setting. They have provided me with a copy of the phone extraction, and we have made arrangements for me to review the TJJD file.
All right, and are you prepared to make an offer or was an offer tendered?
No, ma'am, there hasn't been an offer yet. We would appreciate a recess so we could make an offer to the defense judge.
All right, I'm going to recall you all for March 18th. I'm sorry, not March 18th. Yes, March 18th. And on March 18th, state you need to be prepared to make an offer.
Yes, ma'am.
All right, once you sign the reset form, you'll be excused. Make sure you're on time next time. Do you understand?
Yes, Your Honor. Thank you, Judge.
Oh, you're welcome. Just 1 second. I keep forgetting it's 2024. Oh, gosh, it is.
Your Honor, I apologize. I forgot to address something. Would it be able to approach again?
Yes.
Okay. Um,
Yes.
Your Honor, I apologize about that. Forgot to address Mr. Ashbaugh. We filed a motion to modify his bond conditions yesterday. We're just asking that he be allowed, he's on full GPS house arrest currently, that he be allowed to take his daughter to, is it school or daycare? School, in the mornings. His girlfriend who he lives with, the mother of the child, is currently enrolled in college and is not able to take her in the morning. It's placing a hardship on the family. We're just asking for a 1 hour window of time in the morning that he be allowed to take his daughter to school.
Just one moment. I think I have a motion here.
Also have a copy for the court in case it is not in the court's file.
Yes, I have it in the court's file, but I don't have an order attached.
Copy of the order, Your Honor.
State, are you going to have any objections to him dropping his daughter off at school? And
Yes, Your Honor, due to the nature of the charges, we are opposed to this motion. We'd request a hearing.
all right. So what I can do is I can forward it to Judge Nahara for a hearing. We're currently in a jury trial.
Yes, Your Honor.
So I'll let the clerk know and we'll see if maybe Judge Nahara can hear this today or when he can hear it. All right, is there anything else?
No, nothing further, Your Honor.
Okay,
Thank you.
thank you. You're welcome. Yes. All right, there's just. Are you all ready on Lamar? Okay, all right. All right, is that the person on the Samsung who's not dressed appropriately for court and appears not to have a shirt on? All right, so they will not be given a victim impact if that is the person. All right, and then there's someone on by the name of Bachelor Santabanas. All right, so then Samsung appears to be yours, so that person will not be given a victim impact.
Yes, sir.
All right. I think everyone should know that you have to have clothes on in court. Oh, well, he's at the end of the pile. All right, court is calling 2023 CR 3848, State of Texas versus Michaela Elise Johnson. Can I have parties announced for the record for the state? Defense?
Patrick Hancock for the defendant.
All right, and are you Ms. Johnson?
Yes, ma'am.
All right, we're here for sentencing. You entered a plea of no contest to robbery on December 4th. According to the plea bargain agreement, punishment is to be assessed at a cap of 8 years in the prison. The state is opposing your application for community supervision or deferred adjudication. They're taking certain items into consideration. All right. Did you all have a chance to review the PSI report, state?
Yes, Judge.
Defense?
I did, Your Honor.
Any objections to the PSI report, state?
No,
Defense?
no, ma'am.
All right. State, any witnesses?
No, Your Honor.
Defense, any witnesses?
Yes, Your Honor, I do. I have Miss Alicia Franklin, Michaela's mom.
All right, Ms. Franklin? Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth, that nothing but the truth, so help you God?
I do.
All right, you can lower your hand. Make sure you keep your voice up so the court reporter can hear. If you can state your name for the record.
Alicia Franklin.
All right, defense?
Miss Franklin, good morning.
Good morning.
You and I have spent a lot of time together regarding Michaela, is that correct?
Correct.
And you are aware that Michaela has accepted responsibility for a robbery here in Brick County?
Correct.
And today is the day that the judge can either send her to prison or entertain her application for probation or deferred adjudication.
Correct.
Ms. Franklin, let me just ask you, how old is Michaela?
As of now, she is 18. When the case started, she was 17,
And when did she turn 18?
November 3rd.
And where is she a student at?
At Roosevelt High School.
What grade is she in?
She's a senior.
And being in Roosevelt High School, has she made future plans, applied to any universities or done anything at this point in her senior year?
Yes, she was accepted to UTSA and we're pending,
Excuse me, please whisper.
Say it again, ma'am.
She was accepted to UTSA and we're pending, the application for Clark Atlanta University.
Very good. And how is she doing in school?
She's doing good. She's on my honor roll. Right now she has all A's and, perfect attendance since she's been out.
And did Michaela request a letter from one of her school counselors to offer to the court today?
She did.
John, I tendered this to the state for their review. At some point, you'd like me to look at that, Judge.
All right, any objections to the court reviewing this? All right, you may continue.
Ms. Franklin, with regard to that letter, is it a positive review of how Michaela's doing at Roosevelt High School right now?
It is. Michaela's, right now, since her release, she's at the best she's ever been. She's focused, she's serious about, furthering her future, for college, and she's on the right path.
I'd like to take you back to, I guess, the time around this offense. And before I do that, I want to ask you, are you a single mom?
I am.
Does Michaela have a father in her life who's active or?
He's not active, not consistently.
And does she have any siblings?
She does. She has a brother and a sister from her father.
But living in your household is just
No,
you?
no one, just me and Michaela.
I want to take you back to around the time of the offense. Do you remember getting a call that Michaela had been locked up for some very serious offenses?
Yes, I do.
And can you tell the court what your response was?
That she needed to sit there. I left her in there. She needed to understand what she had done and take responsibility. I left her in there for 5 months before I bonded her out. So she could understand that she didn't do anything, it wasn't something small. She needed to understand exactly what she did and what she could look forward to. She needed to know what prison or their county was, what jail was.
And do you think those 5 months had a significant impact in her life?
Most definitely. I know for a fact she doesn't want to go back. She definitely has a true meaning of what jail is.
And was that your goal at that time?
That's definitely was my goal, because I could have bonded her out the same day or the next day. I mean, I could have got the financial means to get her out. So it was definitely my goal for her to learn her lesson, and hopefully we don't ever have to revisit this again, which I don't think we will. I honestly think that she did learn her lesson.
Miss Franklin, let me ask you, at the time when she was arrested, were there some behavioral problems that you picked up on?
Yeah, there was, but I thought she was just being a rebellious teenager. I didn't realize she was like depressed and had low self-esteem until she had suicidal thoughts. I took her to Little Ridge, but they let her out and she did a little counseling here and there. So I thought she was just being more rebellious to herself. I honestly didn't know it was mental health issues there. But once I did know, I've gotten her help.
What mental health issues have you discovered regarding your case?
Definitely depression, low self-esteem. We've been going through exercises with the counseling sessions. And me, myself, just trying to boost her up and get her on the right path to feel good about herself.
And do you think you're on a positive path right now?
Most definitely we are.
She's back living at home.
She lives at home. Our relationship is really good. She's more open. We actually have conversations about how she's feeling, and I think we're on a really good path.
And that's different than what it was before the.
Most definitely, she would stay to herself more, so lock herself up in her room. Just for me, what I thought was normal teenage stuff, but evidently it was a little deeper than that.
Ms. Franklin, you own the business. Would you tell the judge what you do for a living?
I do. I'm Sugar Glamour Salon, a hair salon in San Antonio.
And have you and Michaela talked about her interest in working in the salon?
Yes, but actually before this, she did. She was my assistant, and to be honest, I need her back as an assistant. But she wants to be a barber, and to get her through college, it'll be something for her to fall back on. And I can. I'm also an instructor, so she can get some of her hours through me.
You mentioned that she's been accepted to UTSA.
Yes, she's been accepted to UTSA, but she's also, we're pending the application for Clark Atlanta, which she preferably would want to go.
And what would be her interest in studying in college?
Business marketing.
So you left her in jail for 5 months, and now she's been on pre-trial release as a condition of her bond.
Correct.
I know we had one GPS circumstance that we had to take up with the court, but
Yes.
other than that issue that was straightened out here in the courtroom, do you think she's been compliant with all the rules?
Yes, she's been compliant, and I also make sure she's compliant. I mean, we get home on time, way before time. We don't take no shortcuts. So yeah, she's definitely compliant.
I know that today we had the opportunity, the three of us, you, me, and Michaela, to go through the pre-sentence report. You can see there are some pretty raw feelings on the part of the listed complainant.
Yes.
Can you tell me if you think, even before today, do you think Michaela recognizes just how serious this offense was and the fear that people were placed in and the after effects of that fear?
Yes, she definitely recognizes that. She's definitely voiced how remorseful she is for this. I know for Christmas we did, she wasn't able to actually go to the battered women's shelter, but she did produce a toy drive. So where she marketed it, and we received a lot of toys, I think over 500, and took it back to the battered women's shelter. She definitely is remorseful, and she definitely understands that she put these people in fear, and it's not to be taken lightly.
Very good. Could you address very quickly whether you think your daughter would be a good candidate for probation or deferred adjudication in this court?
I think she would be a great candidate. I think, matter of fact, I know she has a bright future. This was something that she got herself into that I know she regrets. And I don't think that she should be sent to jail. She's done 5 months, and I understand that it's not the same as 10 years, but she definitely recognizes and has had a taste of what jail is, to not do this again and not be in any more trouble, and to succeed and hopefully help other juveniles and help other people who are going in that direction.
Ma'am, that's all the questions I have. The state has an opportunity to ask any questions they want.
Yes.
Any questions?
Were you aware that this offense occurred on February 8th of 2023?
Once I got a call from the Michaela when she was already in custody.
So you knew the date?
Yes.
And what day was that of the week? Do you remember?
I do not.
Would it surprise you that it was Wednesday?
I mean, I don't know.
It was a Wednesday.
Yeah.
Would it surprise you that this offense occurred shortly before 1 p.m.?
The whole thing surprised me.
But I'm asking specifically about the time at which the offense occurred. Would that surprise you? Did you know that it happened?
I did know. I mean, I've known since by reading the papers, and
Where should Michaela have been?
she should have been at school.
So do you know, or did Michaela ever talk to you about what happened during this offense?
Yes.
So you were aware that the victims in this case was a mother and her young 4-year-old son.
Yes, sir.
And you had a chance to read the victim impact statement.
Yes, sir.
And did it shock you that this had a drastic effect on that family?
No, sir, I definitely understand the turpitude of the case.
So you understand what the victim's feeling when she's saying that prison would be appropriate here?
I don't think it would be appropriate for Michaela
And ma'am,
for the simple fact.
I'm gonna ask if you
Listen.
could answer my question. Would it surprise you or does it shock you that the victim in this case is asking for prison?
No, sir,
Is it understandable?
it definitely is understandable.
And were you aware that the other two people that participated in this act, that they were both younger than you?
Yeah,
So she was the oldest one out of the group, right?
okay, yes.
So she should have been able to make better decisions than the other two, correct?
I don't agree with that. The other two had been in trouble, I understand, and she also was the only girl. So,
And specifically her role in this act, were you aware that she was the person that drove the car that boxed in the victim and her son?
I understand that she was the driver, yes, sir.
Specifically that boxed in the victim and
I
her son?
understand.
Nothing else to say.
All right, any other questions?
Ms. Franklin, I think I tendered it to the judge as a part of the other letter, but we did take Michaela to be evaluated by Mark Harris.
I did,
He's a licensed therapist, is that correct?
yes.
Judge, if I didn't give you that.
Yes, you did. And I reviewed it.
Okay.
It's
very good.
attached to that.
Thank you, Judge. And you had the opportunity to look at his assessment, and that's helped you on a path of understanding her now, is that correct?
Yes, it did.
All right. Thank you.
Thank you for coming in. All right, defense, call your next witness.
Judge, that's it.
All right, did your client wish to say anything?
Judge, I think I'm gonna speak for her.
All right, so I want to let the parties know that part of my question, or maybe you can address this, counsel,
Yes, ma'am.
because it says that she is minimizing her role. And it says regarding the instant offense, the defendant stated, I have no comment at this, which I understand.
Sure. That was
But
me.
then she comes back and she does make a comment. And it says the defendant later stated, I feel it needs to be looked into more rather than what they are saying.
And I think we addressed that actually this morning, Judge. I think her point on that is she was charged with aggravated robbery. She did not possess, hold, or yield a gun. And so it's been kind of a process of explaining that to her. So I think that she's not minimizing her role as far as doing things with those young men. However, I think she's made a distinction that contrary to what the state wants to put forward, is that she was not the leader of this. She was a follower in this, and she did not possess or hold a gun. So I think as to Miss Ballard's point in the PSI, maybe she could have gotten out of the car and said, hey, don't do that. She didn't do it. But the point of the matter is that she was in the car and not actively terrorizing these people. I make that distinction, but I also understand that if she's there, that she's a part of it.
All right, because I'm reading the PSI. I'm sorry, reading the stipulations. And the stipulations, it says that she was the one who boxed the driver in.
Well, Judge, we're here taking responsibility for the facts. So I don't think she has said that she's not guilty of this offense. I just think she has a different interpretation of her role versus those young men.
All right. All right, anything else from the state?
Your Honor, I was informed by our victim advocates that the witness on Zoom was dressed, it was a brown sweater, that's what she's saying that she was wearing.
No, the person who was on Samsung, that wasn't a brown sweater. Unless I'm colorblind or something's going on, they had on no top.
Well, all right, Judge, I just wanted to make sure just.
All right, thank you. All right.
I don't want to overstep, but I do want to make a brief argument next time.
Yes, you may proceed.
So Judge, when I first started representing this young lady, she was in jail. And as her mother said, usually I have to field those questions, how quickly can we get out of jail? I think Ms. Franklin took a very brave approach for a single mom. And that is that I want her to sit there. These are serious charges. I want her to get a taste of incarceration. I want her to understand that you have to be penalized or punished for the things that you do. So 5 months passed by. And so I think that the value in that here in the courtroom today is that she has a taste of incarceration. And I think she's come out of jail, Judge, and the letter from the Roosevelt High School from Ms. Howard says she's really doing well in school. It's hard for me to believe she's 17 years old when I met her and charged with such a serious crime. And she's turned 18 and she's only, 3 months into her 18th year. So, Judge, it's one of those things. She's got a bright future. She's got hopefully acceptance into a school in Atlanta. She's been accepted to UTSA. Those letters, in my opinion, Judge, from Roosevelt High School, those are hard letters to get for the defense. And that's a really fine letter that supports Michaela in her application for probation. I don't want the court to think that she's minimizing this because we've spent hours talking about, the what ifs and how you can't find yourself in that situation. Her mom was bright enough through some talking that we had to get her sessions with Mark Harris. And Mr. Harris is very good through the juvenile probation and through private practice of bringing these young people in. Young people, he specializes in young offenders and working with them with this cognitive behavioral. You can't find yourself in the situation. You can't find yourself around the situation. If you do, then you need to leave. You don't need to be boxing anybody in cars. So I think this has been put square upon Michaela. I think she's done a great job out on bond. I think she's doing a great job in school right now. I can tell you that her relationship with her mother has never been better. I just really beg this court to give this young woman a chance. A conviction and being sent to prison is going to irreparably change her life. Now, I know that there's victims out there who have had their life irreparably changed too. There's nothing we can do about that. But this is a young lady who's clearly on a positive path. And we'd like for her to stay there with the court's permission.
State.
Judge, the situation here is that they specifically targeted a mother and a young child. That child's been damaged for the rest of his life. He's gone through immense trauma. And the role that Ms. Johnson played here was an important one. She boxed them in. She's the reason why they could not get away. I understand that she's made a lot of progress after the fact, but in that moment, she could have made different choices. Choices is what she's gonna have to make going forward. It's something that the state feels that prison would be appropriate here. The victims feel that prison would be appropriate here. That's what we're asking for.
Judge, I just want to, you see more of these PSIs than I do, but it looks like the juvenile offenders who I think have the more serious role in this. I can't read this correctly, but it looks like one of them had his cases dismissed, maybe placed on probation.
Mm-hmm.
And then one was sent to some kind of TYC placement. So I guess if I look at that, Judge, I just argue that there will be some kind of equitable position here by the court to figure out what to do with Michaela. Again, Judge, deferred adjudication on second-degree felony is quite a good thing. I mean, we all know what deferred adjudication is, but sometimes it doesn't mean a do diddly damn in court. Here, it makes a big difference because it gives her a chance to prove herself, and it gives the court a long leash to make sure that she's doing well. I don't know what else we could bring to court to show that she's remorseful, doing well at home, doing well on her conditions of bond. So again, we would ask that the court wisely place her on deferred adjudication. Understand that she's done 5 hard months in the Bexar County Jail. I think she spoke about her fear of the jail with Mark Harris in that letter. I think her mom made a good decision, and we're hoping that that will sway the court and giving her a chance at a future without being another young Black female with a conviction on her.
Here's the court's problem. And what I think people need to look at. Sometimes punishment, and all attorneys will tell you, when we're in law school, they tell you about the purposes of sentencing. Sometimes the purpose of sentence is for rehabilitation. Sometimes it's just punishment. Sometimes it's protecting the community. There are a whole host of reasons. But your problem is sometimes when you've done something that is considered so horrendous, right? No matter the changes you've made, sometimes it's just a prison offense. There are a lot of people who do things that I'm sure if they could go back in time, they would have changed it. They would have said, I wouldn't have done it. But the boxing of someone in with your vehicle, and I read the PSI report and I read the stipulations. In the stipulations, the driver of the vehicle said, hey, my son is in the car. And that didn't give anybody pause. I would think that there are certain things that should give people pause. For example, if somebody holds somebody at gunpoint and they want to steal their vehicle, they would say, oh my gosh, shucks, I didn't know there was a child in this car. Let me pause. But they gave nobody pause. Everybody just still continued with what they were going to do. That's a problem for the court. So this is what the court.
Isn't the problem that she was, no matter what her role was, it was still going to be something that was horrendous because it's a robbery.
Yeah.
So and I'm not trying to argue with the court, but under that circumstance, then no one should be eligible for deferred adjudication.
Well, counsel, as you're aware, there are different types of robbery. And there are some robberies that don't involve a child. State?
Your Honor, so right here, one thing I did notice in the letter for the psychiatrist, something that is bothering me, I've seen it somewhere in here, is that Ms. Johnson, she said she gave them a ride but did not know their intentions, but she played a role in boxing them in. She says that she had never had or handled a gun that night. When the police let up her car, the boys threatened her if she didn't keep going. One of the boys threatened to shoot her if she stopped. Nowhere is that brought up in the report that she had mentioned that she had said that they had threatened her. So that's just something that is.
Well, I don't think it's her feeling. So it's not going to be in a police report.
Right,
but I can tell you that was her feeling on this. She did feel threatened by these 2 young juvenile offenders. But we're here today to take responsibility and not make excuses. So that's our answer to that, Judge.
All right. Is there anything else before the court makes its ruling?
No, Your Honor.
No, Your Honor.
All right, this is what the court is going to do. Court is going to find you guilty, taking consideration 2023 CR 3850, 2023 CR 3849, grand jury number 806632. There's to be restitution of $110 to John Bright in grand jury number 806632. Give you credit for any time served. I'm going to retain jurisdiction. Your attorney will tell you what that means, and I'm going to sentence you to 6 years in the prison. Did you review what it's entitled trial court certification with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. And Mr. Hancock, you can explain to her what that means.
I will, Judge.
All right.
In this emotional courtroom sentencing, a young woman breaks down as a judge explains why one terrible decision has now changed her future forever. Defense attorneys beg the court to spare Michaela Johnson from prison, arguing she completely changed her life after her arrest. They explain she has been doing well in school, rebuilding her relationship with her mother, and staying out of trouble while on bond. She's clearly on a positive path. Her attorney asks the judge to place her on deferred adjudication instead of sending her to prison, warning that a felony conviction could permanently destroy her future. But prosecutors strongly oppose the request. They remind the court that Michaela played a key role in a robbery involving a mother and young child after helping block the victim's vehicle so they could not escape. That child's been damaged for the rest of his life. The judge then delivers a painful lecture about punishment, accountability, and how some crimes are simply too serious for probation. Sometimes it's just a prison offense. The courtroom grows silent as the judge explains that even after hearing a child was inside the vehicle, nobody involved stopped the robbery from continuing. That didn't give anybody pause. Defense attorneys argue Michaela was threatened by the juvenile offenders involved and feared they would shoot her if she tried to leave. But the judge ultimately decides the seriousness of the crime outweighs her progress since the arrest. The court is going to find you guilty. The judge sentences Michaela to 6 years in prison while ordering restitution for the victims. What begins as a plea for mercy slowly turns into a devastating reminder that one moment, one decision, and one bad group of people can permanently alter someone's entire life. Question: do you think judges should prioritize rehabilitation more for young first-time offenders involved in violent crimes? Like and subscribe for more real courtroom moments.